Watch, I want to take you directly now to the Constitutional Court for reaction on this judgment.
All she said in her mother tongue was "Igama kulivumile." I can't translate it because I'll spoil it, but it simply means that she had accepted what had become. It is well with her soul, but she was basically thanking her ancestors. It's been a 4-year-long journey. And to be fair to my client, and I'm going to ask you to just bear with me when I paint you the picture so that you can understand why she feels the way she does. And I'll try not to take too much of your time. I propose to give you basic objective facts, which you are more than at liberty to verify independently. In fact, I challenge you to do so as members of the Fourth Estate and opinion shapers. This case started in April 2015, emanating from 3 separate judicial criticisms. As a result of that, the GCB itself approached, rather the NPA approached the GCB to say, in the face of these judicial criticisms, as a custos morum of the profession, please do something. The GCB undertook to bring an application for their striking out on condition that the NPA pays, and that agreement was reached. You were there, Mr. Stirman, at the inquiry. That was not disputed, even by the CEO of the NPA. Be that as it may, we went before Justices Lekhodi and Hughes. And one of the points that we took on their behalf was that the correct approach, in our view, was that the Section 12(6) inquiry would have been the appropriate route. However, the judges disagreed with our contention, and the court assumed its disciplinary role. She was facing 3 separate counts of criticisms. Before Judges Lekhodi and Hughes, she was found guilty, and I'm using the language very loosely to simplify it for the viewers out there, guilty on 1 count, and the court found that in relation to the other 2 counts, no misconduct against her was proven. But the court in the end felt that on that 1 count, in relation to how she handled the Mrwebi case, she needed to be struck off the roll. Aggrieved by that decision, we were instructed to bring an application for leave to appeal, which was granted. We then went to the SCA as the appellants on her behalf. At the SCA, we were hoping to argue against this 1 count against which she was found to have misconducted herself. But at the end, the SCA found that we should actually re-argue all 3 criticisms. The SCA ventilated every single one of them. And in the end, the majority found that the GCB had not proved any misconduct against Advocate Jiba. That is why the issue of her striking off did not even arise, as confirmed by the ConCourt today. With regard to Advocate Mrwebi, the SCA found that misconduct was found, but the censure did not warrant a striking off, and instead it was replaced with a suspension for 6 months, which was antedated, which resulted in both of them going back to work immediately. My client always accepted that any party to the legal proceedings has got a right of appeal, as exactly as she had. The GCB, aggrieved by that decision of the SA, uncharacteristically appealed to the ConCourt, hoping that the ConCourt would overturn the SCA decision. We said to the GCB again, you are not raising any arguable point of law of public interest, neither are you raising a constitutional issue. In our view, what you are seeking to do is simply to overturn the factual findings of the penultimate apex court, which we felt that was incorrect. But be that as it may, we were dragged here. We took that point again before the ConCourt to say the GCB's matter ought not to be engaged in this court, because in our view, this court has no jurisdiction. And the court consequently found that we were incorrect. And you see what is important? It was a unanimous judgment. 10 judges agreed with us. Now, no one can come back and say it was a split decision, like the kind of criticism that was leveled against the SA to say it was a 3-2 and therefore it was a matter of public interest. The ConCourt has put paid to that. But to gravitate towards the question that you are all itching to ask me is where to from here. Yes. On behalf of my client. We all know that in the intervening period, after the SCA had effectively overturned the lower court's judgment, FUL, the DA, your latter defenders of democracy, subjected our client to similar challenges, which resulted in the president instituting a 12-6 inquiry. The very inquiry that we said right at the beginning in 2015, my client was prepared to go through, we were dismissed. Be that as it may, we are called upon to make submissions to the president as to why they should not be suspended pending the 12-6. We said, no, they don't even need to be suspended. They can voluntarily go on special leave, which was the case. And we raised the point with the presidency with respect to say, as matters stand, there is no court decision on the facts against our clients. Our submissions were not accepted. By the time the Mokgoro inquiry started in November 2018, we had already received a date of hearing in this ConCourt, and we suggested to the president that it would be perhaps prudent for him to wait for the ConCourt process to be finalized. Those submissions, of course, were not received favorably. We then went before the Mokgoro inquiry. At the Mokgoro inquiry, we took the point again to say, you are creating a legal conundrum because an inquiry of that nature does not have the power or the authority to overturn the factual findings of the second highest court in the land. We are assured at that point that no, the inquiry is operating on a broader mandate and it is not going to seek to overturn the factual findings. We then subjected our client to that process. It is water under the bridge. We all know that at the conclusion of that process, she was found to have not been worthy of office on precisely the very same 3 criticisms about which the SA had already pronounced. We accepted that. The recommendations were then that she must be dismissed pending the finalization of a parliamentary process. So said the Mokgoro report. We are called upon again by the president, as he should have, to make submissions as to why he shouldn't accept the recommendations from Justice Mokgoro's inquiry. We made a 44-page submission. And interestingly, the communicator for the presidency picked one line and painted a picture that instead of making submissions, our client pleaded for an alternative job. But that's a debate for another day. It is there. And I'm challenging you to look at whether or not I'm lying to you when I said we made a 44-pager in terms of submission. But cut a long story short, our submissions were unsuccessful, and the president notified us on or about the 26th of April that she has been fired instantly. We again took issue to say, even if we disagree with the findings of the commission, but the commission itself or the inquiry itself says pending a parliamentary process. The parliamentary process had not even undertaken, and yet our client was summarily, dismissed. It also happened at the time where the 5th Parliament had prorogued. So there was no Parliament to take the matter to.
So are you still taking the matter to the Parliament?
Just wait for me. It's not for us to take the matter to Parliament. There is no obligation on us. It is an obligation constitutionally imposed on the President to seek concurrence of Parliament. When that will happen, it is not something that my clients can drive.
But then is your client still going to make representations?
That, Mr. Stillman, I am saying to you, at the moment, it's a fact that the parliamentary process has not happened. That's the first thing. We can't chase that. But obviously, as and when it happens, and we don't want to preempt the outcome thereof, but realistically, we can accept that she's going to be fired. When that happens, the 12-6 process at that point then becomes finalized. We hold instructions to then take the Mokgoro report on review. It is something that we couldn't have done before the ConCourt had pronounced. Now that the ConCourt has pronounced, we will then polish up the version of the review application that we had already started preparing a few weeks ago. But it would have been imprudent, it would have been untactical, it would have been disrespectful of the process to start a review of a process that itself has not run its course. So now that we are now awaiting the parliamentary process to happen under the 6th administration, depending on what that parliamentary process decides, it may either concur with the president or it may disagree. Only at that stage will we then take instructions and advise our client on what the next possible course of action would be. I cannot, you are itching for me to say we are going on review today. I cannot, it would be silly to say so, because that process against which we have instructions to launch a review application has not been completed. I'm not here to chase a deadline. I'm not here to do a dialect code, response to a question. I'm simply giving you objective facts that we can go and verify. So as matters stand, we are pleased with the ConCourt's outcome, but my client is equally sad because what was supposed to be the end is actually the beginning of another possibly 3-year journey, because we know she doesn't have the media shouting praises in her corner, and she has kept a dignified silence all along, which is why she has instructed me to at least address you this one time and once and for all. Because once all of these processes are finalized, the only place at which she will fight her battles is in courts of law. Now, a review will have to be lodged in the High Court. We may or may not succeed. We'll probably end up in the SCA where we may or may not succeed. And then we're back here in Braamfontein. That's also another 3-year journey. If you judge by where we started in 2015 to where we are now, you can realistically accept that it's not going to be over anytime soon. And she's entitled to ventilate and protect her rights through the rule of law and through the courts. That's why my client, in fairness to her, she's never opened her mouth for the past 4 months, 4 years, when all and sundry had things to say about her, but she understood that she's an officer of the court. She maintained a dignified silence. We gave that advice, and she stuck to that advice. She said, even beyond today, we're all going to remain stum, wait for the parliamentary process to be finalized. We only speak at that time in terms of what our course of action would be. We remain stum again and wait until the entire review judicial process has been finalized and then speak. That is how she has conducted herself as an officer of the court, and that's pretty much where we are. And while we at it, Mr. Stirman, I find it very interesting, and colleagues from the Fourth Estate, that the latter-day defenders of democracy, our professional body as well, has had nothing to say about the conduct of Mr. Willie Hofmeyer, who himself was criticized in the strongest terms in the Supreme Court of Appeal in the DA versus Zuma matter. I have a copy of the judgment which I can give to you for free. Read from paragraph 64 of that judgment to about paragraph 90 and hear what the majority through the pen of Justice Nafsa have to say about the conduct of Mr. Hofmeyer as a senior employee or official of the NPA, who happens to be of the same rank with my client, by the way. That judgment was handed down in 2017. Everybody remained quiet. Even after Advocate Arendse, who led us, raised this issue pertinently with Mr. Hofmeyer and cross-examined him for 2 days, who, during the course of the cross-examination, asked to consult a senior counsel, who asked to read the judgment that pertained to himself and ended up conceding before Justice Mokhoro. No one picked it up. Now the question then becomes, and this is what my client's feeling is, because you want to know how she feels. She feels that some cows are holier than others. If you read that judgment, and I challenge you to read it, it's not Majavu speak. It is what Justice Nafsa had to say. If you look at what he said in that judgment, if you read what he said in the Phillips judgment and find out how much the Phillips matter has cost the NPA. Phillips is the case involving the ranch, where people go for adult entertainment. Don't take my word for it. Don't believe my client's instructions. Go ask the NPA. Nothing was done about it, even at the level of just establishing an inquiry, to just say, these judges have spoken, let's look into this conduct. How different is Advocate Jiba from Mr. Hofmeyer? The fact of the matter is this. The fact of the matter is this. If anybody is serious about cleaning up the road at the NPA as it is suggested, surely we should be sweeping equally across the board. And those are my client's instructions, not my instructions. And I am challenging you to find out if the DA did anything about that conduct, if FUL did anything about that conduct, if the Law Society did anything about it.
Does the client want her job back, or does she just want to clear a name following the parliamentary process that you anticipate will lead to her dismissal anyway?
My client wants to subject herself to the rule of law because he believes she's not above the law.
Does she want her job back?
He vindicated Mr. Stirman. Obviously, at the end of it all, she will decide at that time whether she still has the appetite to go back or not. But she's perfectly within her rights to vindicate her rights or to let the courts decide her fate. Why should it be different? Why should I answer you definitively today whether she wants her job back. That's not the point. That's besides the point. She never accepted a payout. When there was criticism against her, she subjected herself to 7 court processes, 1 parallel inquiry. She's still prepared to subject herself to further court processes now. She didn't say, let me walk away from my job, take a settlement package, but rather she said, let me subject myself to the rule of law. That is what she wants to do. She wants to subject herself to the rule of law. She may decide that she wants a job back, or she may decide that, look, you know what, the waters have been contaminated, she'll walk away. But imagine if she had walked away amid these allegations without subjecting herself to legal processes, you guys would have a field day over here.
Mr. Majavu, I'm sure we are certainly going to read provisions of that judgment, but for the benefit of our viewers, if you can just paraphrase it for us.
The bottom line is the Supreme Court of Appeal found that Mr. Hofmeyr, in as much as he thought he was promoting the objects of the NPA, he actually subverted those objectives and achieved the opposite. Paragraph 81 specifically deals with that. But it's not for me to interpret it for you. All I'm trying to say is he too was subjected to judicial criticism. Was there any inquiry against her, against him? None. Did the professional body, the Law Society, because he is a member of the, sidebar like myself, do anything about it? None. Even when we raised it in an open inquiry that you covered, Mr. Stirman, nothing happened. The media did not even run a narrative that says, but hang on, let's look at this particular conduct. Now, my client personally told me that
Well, to be fair, the inquiry was looking into the fitness of Jiba and Mrwebi, not that of Hofmeyr.
I am talking about fairness, exactly the point. If you want to be fair, fairness is not one-sided. You cannot be selective in your pursuit for justice. But the point is this. We raised that issue and nobody ran with it. And I am raising it again today. Bottom line is, it is not up to her to say what should happen. But you asked me how she feels, and I'm telling you how she feels. She feels that some cows are holier than others. She feels that she's been targeted because she's a black and a female. Whether I agree with her or not is another story. Those are her feelings and those are my instructions.
I wanted to ask a question relating to perhaps the motives of your professional body and those who pursued this particular matter up to now, even when the SCA, for instance, had overturned the High Court decision. What, beyond her being a black female, do you think there are other political motives for whatever reasons that are underlying this?
I do not know. I am not in a position to say so. I'm just a lawyer acting on client's instructions. I practice law fair, not media fair. And it would not be correct for me to speculate about motives. I am only telling you what her instructions to me are. Her instructions are very clear that she believes that she's been targeted on account of her race and gender. I don't have to agree with her, but that is what she necessarily believes.
All right, thank you. Thank you very much.
Thank you.
Stirman, there is that. I hope you put it on frame and see.
It's my job.
Sorry.
All right, there you go. That was Advocate Jiba's attorney Zola Majavu. They're basically mapping out the way forward, saying that they are awaiting the parliamentary process. After that, a decision will be made on the way forward, whether to launch this review or not. So breaking news on the agendas. Watch the Constitutional Court in an unanimous judgment dismissed the General Counsel of the Bar of South Africa's appeal of the Supreme Court of Appeal judgment. You'll remember the SCA ruled that Jiba and Mrwebi not be struck off the roll of advocates. Now, the GCB submitted that there were constitutional issues, but as you heard, the Constitutional Court said that the GCB has not established that this falls in the Constitutional Court's jurisdiction. So more reaction on this breaking news story shortly. Now,